And there's plenty of case law that says, the right to compulsory process is meaningless unless it can be backed up with judicial action, contempt, or writ of attachment. And that, a defendant has a right to put on their case and their theory of the case. However, again, Mr. Cohen brings up that the right is not unfettered. You can't just harass people who are not involved in a case. And let me cite to Hoskins versus Wainwright. It is a federal case out of the Fifth Circuit from 1971 at 440 Fed 2nd 69. And I'm quoting in pertinent part, the right of compulsory process is not absolute, and the state may require that a defendant requesting such process establish some colorable need for the person to be summoned, lest the right be abused by those who would make frivolous requests. And it also cites back to Washington versus Texas, a 1967 case decided by the United States Supreme Court at 388 U.S. 14 or 87 Supreme Court 1920, which again discusses that there is certainly a right to compulsory process and a right to call witnesses for your defense, and this is basic to our system of justice. But it's not unfettered, and there comes a point where it can become abusive. Ashley versus Wainwright are cases out of the state of Florida. Got kind of a history. There's Ashley versus State at 433 Southern 2nd, 1263, a first DCA case from 1983. It was further then appealed, Ashley versus State 479 Southern 2nd, 837 in 1985, same case, and ultimately made it into the federal system under Ashley versus Wainwright, 639 Federal 2nd, 258. And again, in that case, they, quoting what the court's already expressed, the right to compulsory process is not absolute. And the person making the request can be required to establish a colorable need for the person to be summoned, lest the right be abused by those who would make frivolous requests. And it, again, goes back to the Washington versus Texas case, where in that case, the U.S. Supreme Court reversed the conviction, saying in that case, the state had arbitrarily denied the petitioner the right to call a witness who was physically and mentally capable of testifying to events that they had personally observed and whose testimony would have been relevant and material to the defense. So I'm asking you, counsel, not some tweet made by or Instagram post or some other post made by another person, not by a person who's not Mr. Green. And later, that with the same degree of reliability or authenticity, there's also a tweet or Instagram or whatever saying, that I didn't post that. That was a hack. Okay? So those are the only two things that we have up there. And if that's all you have, then this is a fishing expedition that the court is not going to sustain any further. We're getting outside the realm of what is a colorable, legitimate defense, and just turning into harassment on it's like a Chewbacca defense.
Except, Judge, that I've already put in writing when the court ordered me to do so the nexus between my witnesses in this case, that Antonio King, 600 Breezy, did in fact fly to South Florida and did in fact post video of himself threatening to be armed and threatening the decedent prior to his death. He further, I know, but I'm letting
Counsel, then subpoena 600 Breezy, what does that have to do with someone else?
I'll tell you.
Who you have no evidence of being involved other than hearsay and innuendo. You are now trying to just drag somebody in who's a celebrity who does not want to be associated with this, and the harm to that individual is not inconsequential.
I'll tell you why. Because that person, Antonio King, then further posted that the reason that he came down here was for Drake. So I'm not making this up. This is out there. But I'm not being allowed to investigate it. All I want to do is take his deposition.
You've had this case since 2018. Go talk to Breezy.
He's on my witness list. I don't know where he is. But Judge, listen, look.
But that's a different hearing. The hearing here is whether or not there are sufficient grounds for this court to order somebody who I have no evidence, and counsel's questions saying, are you aware of, is not evidence. We're all aware that your questions are not evidence. So the detective who investigated the case said he finds no nexus. The relative of the deceased who came in to identify the body said, yeah, I'm not aware of any beef. And when you showed the screenshot of that said, yeah, you know, he disavowed that as being hacked. Was he hacked that time? I don't know. His account's been hacked a number of times. This is beyond you know, what would be considered something that can be authenticated. This is beyond triple hearsay. This is just gossip, rumor, and innuendo, and really doesn't have any place in a court of law.
In any other scenario, if it were not Aubrey Drake Graham, and it were anybody else, and it comes out that before he died, he said, if I die, it's so-and-so, I get to ask you at least, Mr. Graham, do you know Robert Allen? Do you know any of the other co-defendants? Have you ever communicated with them? These are questions that are normal in any scenario. However, and listen, Judge, it's not my fault that the decedent was a rap star, and the person I want to depose is a rap star. It's the Home Depot. Like I said, if a decedent worked at Home Depot, I'm probably going to have some people from Home Depot on my witness list. This is no different. The issue is that the people at Home Depot can't hire Brad Cohen. And Brad Cohen came in here, and all of a sudden, now I'm not even able to exercise my client's right to investigate this case. All I wanted to do was to take his deposition. There's been more than enough from the detectives. And frankly, Judge, that relative, that's a lie. Because everybody, 50% of the population, knew about the issues between Drake and X. Everybody knew it. I believe that she lied on the stand, which is really raises an eyebrow on why that person's going to perjure herself for that question. So, Judge,
your opinion, counsel, is not facts before the court. It's not the testimony before the court. Again, I'm mindful of your client's right to present a defense, and I have gone as far as I think I can to allow him his opportunity for process. But at this point, it appears to me nothing more than harassment of someone in order to set up some sort of straw man, look over here where there's no evidence of that. In fact, even you're suggesting that if your questions are, do you know my client, have you talked to any of these people, that does not absolve them of the charges before them. That's not a defense. At best, that would be adding a unindicted co-conspirator, if you will, but that's not a defense to the individuals that are here. And
Judge, that was just a sample of a question that could lead to another question. It's a question that should be asked of someone. And if it weren't Graham, I would be asking. I would be able to be asking.
No, it wouldn't. Because if it were a guy at Home Depot who came in and said, Judge, I don't know why I'm being dragged in here. I have nothing to do with this. I don't know these individuals. I didn't kill anyone. I don't know anything what you're talking about. they would be entitled to the same relief. It does not matter. And additionally, just, so, your motion's granted,
Thank you, Judge.
your motion's denied,